former federal prosecutor. He's correctly predicted the outcome of so many of these legal cases. He is now working as a defense attorney in California, and he is the great David Katz.
Great to be with you, Mark, Kim.
It
Hi.
is such a delight to see you, sir. And I want you to first, before I get to some of these contemporary cases in there, some big ones for sure, I want you to weigh in on something that Kim and I went round and round on yesterday. I'm a staunch advocate, and now I'm joined by a lot of legislators as a result of a lot of the controversies involving the Supreme Court. But I was an advocate of this before these controversies came to light, of expanding the court. I mean, I just think that would be, we're seeing, leave it aside, all the reasons. I think they're manifest reasons. But Kim was saying, well, kind of like, this is the court you have. You kind of have to live with it, don't you? Although I'd suggest that this court you have because they held out a seat away from Obama. In any case, and somewhere in the middle. We went round and around on this yesterday.
You're talking about putting more seats in, and I'm saying that that could shoot you in the foot eventually. Because what if eventually you get an all-conservative court of 13 justices, or 17, whatever?
You've already been shot in both feet by this, and they're not playing by the rules and holding a seat out. And then I'll let David talk. And the last thing I would say is, by that logic, you should never bring a court case because they may bring a court case against you the other way. I mean, it doesn't. I don't think it holds up. But David, you really are the. Tell us what's involved and what your thoughts are on this.
Well, I think, Kim, you were expressing a kind of conservative, in the good sense, and institutionalist view of the court and of our institutions. But I do have to agree with Mark on this one, that it's been so debased, it's been so politicized, that you're basically just surrendering for decades unless you do something about increasing the number of justices on the Supreme Court. And they had a big commission, and it was a bunch of professors and former judges, and the commission never really decided anything. That was kind of Biden's way of punting on this issue. But, there's nothing in the Constitution about how many members there need to be on the Supreme Court. When the Republic started out, the nation started out, we had about 6. Then in a famous incident during the Civil War, Lincoln went to 10. I can get into more on that. But when people talk about FDR, quote, packing the court, meaning increasing the number of justices on the Supreme Court, they never go back to Lincoln, especially the Republicans never go back to Lincoln, whose Republican Congress expanded the number of members on the Supreme Court to 10, and it was not really very controversial. Now, some people say, well, it's sort of outcome determinative. Well, hopefully things in politics are outcome determinative, right? One side tries to get the outcome that it hopes will occur, and the other side, that's the whatever you call it, the dialectic. That's the difference of opinion. And there's a yin and a yang. There's a push and a pull. And I guess people are just kind of coming to the feeling that the Democrats just aren't pushing and pulling in the way that the Republicans are, who've had this issue in their grasp for decades. The Federalist Society, this is sort of what they live for. And so the idea of going to 13, I think, is probably a very good idea. One solution is to go to 11. 11, if it were passed, and it could be just done by legislation, would put Roberts back in the middle. For a long time, Justice Kennedy was in the middle. Then for a brief time, Roberts was in the middle. But by now, Roberts isn't even in the middle. I mean, there's 5 hard right votes on the Supreme Court. And it's not just Dobbs, overturning Roe v. Wade, but it's also the environmental cases. There's something called the major case doctrine, which seems to be made out of whole cloth by these justices from the Federalist Society, which basically says when Congress decides to do something like control pollutants across the country or emissions, or to do something about the ecological disaster that's happening with fossil fuels. Well, that's a major decision. And so therefore, it has to be very clear that that's what Congress intended. Well, the way to be sure what Congress intended is, did they pass it or not? And if they passed it and it's not unconstitutional, it should be affirmed. It should be the law of the land. And that they go through and they have this major case doctrine. This is just a way to strike down the will of the people as expressed through the legislature and as signed by the president. And so I think it's totally wrong. And if I can just say one more comment about this, FDR's plan to pack the court had some real problems with it. It had some political problems. And while he was very popular at the time, there was a famous line, "A switch in time saved nine." One of the Supreme Court justices switched on what they called substantive due process. And so suddenly the Supreme Court went from throwing out all of the New Deal legislation to affirming it, to letting it go into effect. And that was everything. That was Social Security. That was the relief for the farmers who were going bankrupt in droves, the people on the breadlines in the Depression. All of those, amelioratory measures were suddenly affirmed because a switch, you get it, a switch from 5 to 4 against to 5 to 4 for the FDR programs, a switch in time saved nine. And so that was why his FDR's plan to put more justices on the Supreme Court ended up failing. But as I said, Lincoln did it. It's completely something that can be done by statute. And one more point on this. I think that the Democrats need to really sell it. This idea that it's the 20th agenda item, and at the end of the day, it looks like, oh, what are the Democrats up to now? This must just be a bunch of cronyism. No, it's not. They need to run on this issue. They need to make this issue come alive for swing voters. Some of the things on the Supreme Court, we've never had a Hispanic male on the Supreme Court. We've never had a person of Asian descent, with all of the fantastic lawyers who are Asian American, Indian American. We haven't had one on the U.S. Supreme Court. We haven't had a politician in a long time. Who knows? Maybe Manchin wants to be on the U.S. Supreme Court, or somebody else who's a swing vote who could help deliver the Senate 51 to 49 or 50-50 with the vice president voting for it. This will be a close vote. They're never going to get to 60. But my argument on the fact that they'll never get to 60 to extend the Supreme Court, they don't need to. There's nothing in the Constitution that requires a filibuster. They can carve out from the filibuster rule a vote that they could win this one by a simple majority in the Senate. And
the Senate can do, the Senate can do anything they want on this, David. Right?
And they put these justices on the Supreme Court, Mark, by a bare majority. Kavanaugh, Gorsuch, Barrett, they all made it. I don't think any of them got over 52 votes. So the idea that they could put these three Trump justices on there by 52 to 48 votes, it would be an outrage if they couldn't expand the number of justices on the Supreme Court, right? The remedy for what they've done by a 52-48 vote. The idea that they need 60 is nonsense. And so I think that they should win the House on this. They should say in these swing districts, let's say we have a swing district out here that goes back and forth with two Asian Americans fighting. The Democrats should say, I'm going to put an Asian American on the Supreme Court by my vote. It's long overdue, and we need it. And let the Republican incumbent, who won by 51-49, let her say, no, I won't. And they should run on this thing. Like I said, they should put, I could think of people all over the country who'd be great Supreme Court justices. They don't have to come from the appellate courts. William O. Douglas, many other famous justices didn't come. I think this was Kagan at Harvard, right? I don't think she was on. She was an advisor to the president, but I don't think she was on an appellate court. You don't have to come from an appellate court. So I think they should run on the 13. They should carve out 4 or 5. Remember, that was Trump's brilliance, that he carved out this list of Federalist judges, and he said, I may be a no-goodnik, I may be a totally corrupt, morally bankrupt person, but hey, all of you devout, people who vote on this issue, these right-to-life people, vote for me, because here's the list. Here's the 12 people that I'll put on the Supreme Court who are so-called pro-life. And he followed through on that commitment. And so the rest of it went in one ear and out the other for apparently the Pence voters and the, quote, right-to-life people.
Yeah, the boorishness of Trump and everything, we've been saying this over and over and over again, it doesn't matter. Their relationship with, I'm talking about the Christian right, was transactional. So they knew, we'll put Trump in and he'll give us our judges. And they played, this is McConnell leaving that seat open, not even giving Obama the chance to, have his appointee or his nominee heard. You realize how the dirtiness of all of this. And I love the other thing that you've said, just to underscore, and then I want to move on to this other court case. But I love what you said. I said it yesterday. I would hammer the hell out of this Clarence Thomas thing and out the court's corruption. I'd make it clear that all roads, all conversational roads are going to go to this. I mean, I think it is a winnable, as you suggest, sort of election issue that the Democrats could rally around. I don't know why we don't hear more about it. Let me ask you now about the future of this abortion pill. Now there is a conservative appellate court, I'm told, and you can fill us in, that looks to be doing this same dance with the approval process, suggesting, well, this pill was approved before its safety was actually ensured. They're on that hook. They're hanging a likely decision that will restrict access to this abortion pill. Could you give us a sense of this?
Well, this is the Fifth Circuit. This is the most conservative appellate court in the country. So it's not like the Ninth Circuit went and did this. They cherry picked this district in Amarillo, Texas, for this suit on the abortion medication pill. And they picked the Fifth Circuit as the one that would review the judge from Amarillo. So this was totally set up, judge shopped, and it's in the Fifth Circuit. To make matters even more political, it's 2 Trump judges and 1 Bush judge who are on this 3-judge panel. So I suspect that they will indeed deliver this, quote, pro-life decision against this abortion medication, which is very foolish. Over 200 big pharmaceutical companies have said this is foolish. The next thing that could fall, if this is actually good law, which I don't think it's going to become, would be COVID vaccines. This drug that they're talking about for the abortion medication drug is 3 times as safe as penicillin. So if this were to become a precedent nationwide, any judge in America could issue any federal judge could issue a nationwide injunction until they were overturned by an appellate court against a COVID medication, against penicillin, against just about anything that you can imagine. And that would not only harm the health of the American people, potentially coast to coast and in all sorts of places, like this one's going to affect it in blue states, but it would also affect the market for these pharmaceutical drugs. They raise billions of dollars, they do years of research, and the idea that they could suddenly be struck down and denied a market nationwide is frightening, as I say, not only for the health of the people of the country, but also these economic interests, these pharmaceutical companies that have a huge amount of clout. So that is why I think that while this decision will be made by these 2 Trump-appointed judges and by this Bush judge on the appellate court, I think it may go en banc. En banc is when the entire Fifth Circuit decides about it. That often has 11 or 13 judges on it, and they can reverse. Let's say the decision is 2-1 in favor of restricting this pill nationwide, that they can then reverse it, let's say 6-5 or 5-4 in the en banc decision. If that doesn't happen, then it goes to the U.S. Supreme Court. And I do not believe, I predicted this before, I don't believe Alito has more than his own vote and Thomas's vote to actually keep an injunction in place or to keep a prohibition in place about this drug being marketed, because the drug has been proved to be safe. The lawsuit is way too old. The FDA has expertise, which they applied to this question, and they made a rational decision. And finally, the fact that now they allow telemedicine doesn't really make any sense at all. This is a very safe and effective drug. If a woman is pregnant in the first few weeks, you could telemedicine prescribe this drug just like you could do it in person. This is all based on the myth that it has some dangers that it does not have. As I said, it's 3 times safer than penicillin.
It's the telemedicine that they're hanging. I'm trying to see the law part of it. The weak ass law that they're trying to bring in is telemedicine related. Is that it?
23 years ago, it was allowed. Okay. And then
Right.
generally, there was not telemedicine 23 years ago. People
Sure.
went in to see a doctor. Okay. So then the FDA expanded the authorization a few years ago to say that you didn't need to see a doctor. It was okay if you did telemedicine. What the Fifth Circuit did before, because the judge in Amarillo said basically no, no, no to everything. They said no. They said no to the no. The Fifth Circuit said before that you can allow that if you see a doctor, that's fine. And of course, in some of these places, it's very hard to see a doctor because you may have to drive 200 miles to see a doctor. It's very restricted. They get these doctors, they intimidate them from not seeing young women who need an abortion, poor women who need an abortion. They intimidate these doctors in a lot of these red states. And so what you had is you had the restriction on telemedicine. And so the Fifth Circuit said, well, we have questions about whether you have to see a doctor. So that much looked like it was going to stand. Then the U.S. Supreme Court didn't grant the injunction as to anything, Mark. And so now we're back where there's no injunction. Women can get this pill. It's safe and effective in every state in the nation, including in blue states. But if the Fifth Circuit rules as it looks like they're going to, that panel, and if that somehow survives the tests all the way through the U.S. Supreme Court, then the horrible is that women in California and other blue states couldn't get it. This is not just something in some little area of some red state. This is women hearing my voice, seeing me here in California and other blue states would not be able to get this pill, even though it's safe and effective. The only good thing that would happen, besides the outrage over this, that would certainly mobilize people to do something about this issue and about the composition of the Supreme Court and having only 9 on the Supreme Court. It would not only mobilize people, but there is a second part to the treatment. And so if worse came to worse, women could apparently take the second part. It's not quite as effective. It's also very safe. It's not quite as effective, and it has a few more side effects, which, to get the result that you want, it's a side effect worth enduring. But my goodness, people who say they want to help women are going to come up with a regime that's going to make them take not the first pill, but only the second pill, which is still effective, but which makes them, let's say, bleed a little bit more.
Yeah,
wow,
bleeding,
that's helping
it's painful,
women.
That's
helping women.
Yeah, I mean, this seems like judicial terrorism is what we're looking at, and it's just astounding to hear you catalog it like this. And now I ask for just to reiterate your prediction. Then you're saying if this does go through, as it's suggested there, because this court is loaded the way you've described with Bush and Trump appointed judges, then there'd be a temporary injunction, or there would be a stoppage to this, and then it would go to the Supreme Court, you're saying. But during that time, the pill would not be available even in places like California. And then you're saying, and just to follow through on the prediction part, the Supreme Court would likely overturn that judgment and it would be available again, is what you think would likely happen?
I think it will never stop being available, because I think if the Fifth Circuit issued its ruling, as I think they're going to, then I believe there would be a stay either imposed by that court, would itself recognize that this is so controversial. It's been up to the Supreme Court, and that did not result in an injunction being left in effect, that I think they'd realize that they were really flying in the face of the Supreme Court. Otherwise, I think the en banc Fifth Circuit, the entire court, would not let the prohibition go into effect. And then I think because it's been to the U.S. Supreme Court and they did not allow the prohibition to go into effect while it was being litigated, the U.S. Supreme Court would still not let it go into effect. I believe at the end of all of this, the U.S. Supreme Court, someone said on your show, will they go with their theological side, or will they go with their friend of the rich and huge company side? And on this one, I think that they will go with the big pharma and not big theocracy. They'll go with big pharma and not big theocracy, and that this pill will remain available because big pharma is all in on this issue. And this really would disrupt the pharmaceutical industry. There's things we don't like about them, but I think on this one, maybe it's strange bedfellows, but we're with the makers of this abortion medication drug because it's very safe and effective. And we need these drugs. They may gouge on the price. They may not allow fair competition, but we need a lot of these drugs. For goodness sake, we needed that COVID drug. Can you imagine if they have stopped that in some of these red states and then tried to apply a nationwide injunction so we couldn't get the COVID pills anywhere? What an outrage.
Well, I mean, I think that they're looking increasingly like they may do stuff like that. That's why I was saying that it's a judicial terrorism of sorts. It's absolutely and immensely disturbing, I do want to, dialectic is a ding word, thank you, as is determinative, very strong. I want to actually, very, very good. That's a ding word. Nice job, David Katz.
We attorneys use those too. If this were a pure law show, I don't know if I'd get a ding, but it's great to speak to your audience about these legal issues, and I hope I can make some of this stuff, more comprehensible than when you just read about it in a law journal.
Yeah, I love talking to you for just that reason. I think you deconstruct these things so effectively. And we love your predictions. Tony, you have the mock-up again of David Katz as Nostradamus? No, you don't? Okay. Well, we had it, and we'll have it for your next time. Katsadamus, again, the latest prediction is that the what do you call it again? The bunk. What is it? The court where you say that they're going to, as a Fifth Circuit, when they all meet together.
En banc.
En banc.
New word BANC from French. The court sitting together. Let me just say
course.
one more thing about the
Please.
Supreme Court. Some people say, well, wouldn't more than 9 be unwieldy? When these circuit courts sit en banc, they sit with 11 justices or 11 judges or 13 judges. There's nothing unwieldy about it. They all fit in the courtroom. They can all ask questions in turn. Lincoln's 10-member Supreme Court did just fine. And as I said, with the fact that it's outcome determinative, yes, of course, people shouldn't shy from the fact that this is the only opportunity to try to undo Dobbs. This Second Amendment jurisprudence has gone completely crazy. The idea that people can run around and open carry, that's not at all, even if you give the Second Amendment all its due, it was not. People have gone back and studied this. At the time of the Revolution and thereafter, people did not run around open carrying weapons in big cities of the time. Yes, maybe in rural areas, maybe for hunting, but they didn't run around New York or Philadelphia or Charleston with open carry. This is back in the late 1700s. And then you have the Shelby County case, when you see the African Americans made to wait for 5 hours in line in southern places. You can thank the Supreme Court because there was a Voting Rights Act that even the Republicans voted for. And they said, no, we don't need that anymore because all the southern states are playing by the rules with African Americans. Really? And then we see election after election where they can't get water while they're waiting in line for 5 hours, where they play games and they restrict all these people from the voting rolls. That's Shelby. So they have had a lot of 5-4 decisions, this Supreme Court, and now we're locked for decades into 5-4 or 6-3 decisions. And I think you said this the other day, Mark. They're fighting for this. People who believe in the rule of law and believe in fairness and in precedent have to fight for their side. And the only remedy, you think Clarence Thomas is going to resign? They're going to have to carry him out. And if 1/9 of the court is corrupt, with 13, only 1/13 of the court will be corrupt, and the 4 new members would be terrific. And they can sell this plan, not just as a plan which is totally legal and appropriate, but also on the character and how great those 4 new justices would be, and name some of them like Trump did.
I love it. I love it. The great David Katz. Now, there he is.
I'm better looking than that, I hope.
I hope. Better looking. Yeah, that's just a caricature, but it was well done. It was I think Robert is his name. He did it like within an hour after we were just talking about you. Katsadamus.
One of your viewers wrote in and said that Nostradamus was also wrong. I mean, it's just he was a famous predictor. It's just that he was a famous predictor. I don't want to compare my batting average to his. I don't even know what his batting average was, but he was a famous predictor.
Well, receive the rod of equity and mercy. And take your applause. Thank you, David Katz. Love that you join us, and we'll talk next week. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.